we are going to be going over our Social Security overview. My name is Lauren Schuler, and I'm the Director of the Community Services Case Management Program here at the ARC of San Antonio. And this session is brought to you by the ARC, along with Ms. Alison Packard, who is an attorney with over 20 years experience in helping families with loved ones' disabilities. Some basic housekeeping: all attendees are going to be muted and the video option is disabled. To select the language, again, click the globe at the bottom of the screen, select the preferred language, and then mute original audio so that you're not hearing both English and Spanish. We'll leave time at the end of the presentation for questions, and if you have a question, please type them into the Q&A box instead of the chat box so that we can keep track of them and answer them today at the end. We are recording this session to make it available to more families as well, so please don't use or disclose any information that is private or personal, because we do adhere to HIPAA standards. We will also be providing the link with the recording of the presentation and the PowerPoint for future reference and sharing with others who may be interested. Ms. Packard, the floor is yours. I'm going to go ahead and turn my video off and let you take it over.
Thank you very much. I appreciate the opportunity to be here. Can you see my screen okay?
Yes, ma'am, we can.
Great. Well, I love speaking to groups like this, love the ARC. I appreciate all they've done in my own family, and it's a real honor to be here with you. I am also the parent of a daughter with disabilities. Sorry, I'm trying to make my screen work. I have a 26-year-old daughter with pretty significant disabilities. And so I do this professionally, but as we all know, most of our great experience comes from being parents and working our way through the process. So that's really how I've learned a lot of the things that I hope to share with you today. This is my mandatory legal disclaimer, just reminding you that we're not creating an attorney-client relationship today, and I'm just telling you things for educational purposes only. So we'll take the information you get today, but make sure you talk to an attorney to ensure that it fits to your particular circumstances. Okay, we're going to talk about Social Security. Now, when you think of Social Security, do you feel like this picture? If you do, you are not alone. Understanding Social Security benefits can be overwhelming. It is a crazy language, first of all. It seems like an alphabet soup, so many letters, and trying to keep straight the difference between SSI and SSDI and what is RSDI. It all gets very confusing. Remember, there are literally thousands of laws and regulations that the Social Security Office has to sort through and that we need to understand. Well, we need to understand a portion of those. But disability cases are actually a pretty small part of what the Social Security Office does. And when you consider how much the staff turns over, it's very likely that you may be speaking to someone who doesn't have a great grasp of the knowledge on our particular area. So that's why it's wonderful for us to try to understand it better. Okay, Social Security retirement. When most of us think about Social Security, we think of our own retirement. We know that we're paying FICA taxes into a system, and one day we're going to draw that back as our retirement. And the amount that we get is different for everybody, and it's based on our average earnings over our 35 highest paid years. When we're 65, we're also eligible for Medicare, which is managed by the Social Security Administration. So how much we get depends on what we've put into the system, what we've paid in FICA taxes, but it also depends on the age that we choose to retire. We can draw our retirement from Social Security as early as age 62, but that's going to give us a lower amount. If we wait until our full retirement age, we will get a significantly higher amount. For most of us, that's age 67 now. If you're born after 1960, if you're born after, I think it's 56, you might be 66 in 4 months. So it goes up, but 67 will be for a lot of us. And at age 70, that's when we get the maximum amount. So there's no reason to hold off drawing your retirement past age 70. It's not going to keep going up. But between our full retirement age and age 70, it will increase by about 8% every year. If you want to know how much you're going to get at retirement, you can sign into ssa.gov and create your own account, and it will tell you exactly how much you will get at this age and how much at this age. And I think that's a great idea for all of us to have that SSA account. So what happens if I am paying into the system, but then I die or I become disabled before my full retirement age or even age 62? Well, part of what we're paying when we pay our FICA taxes and pay into the system, we're paying for insurance. Our insurance covers the situation where we might pass away before we get our benefits or after we get our benefits, or we become disabled. And we also have insurance for our dependents. So our spouse might be covered under our benefits, sometimes an ex-spouse, a minor child can be covered. And this last one is very important for those of us who are parents of individuals with significant disabilities. Disabled adult children can also be covered under our own work record benefits. Childhood disability benefits, that is a Social Security benefit for someone who is over the age of 18 and not married, and their disability began before age 22 and is continuous. And when I say continuous, I mean continuous by Social Security standards, by their definition of what disability is. We'll talk more about that in just a minute. And also now that person has a parent who has died, who is drawing their Social Security retirement or Social Security disability. In that situation, it's a very significant benefit. It can be up to 50% of a living parent's benefit and up to 75% of a deceased parent's benefit. So what that means is if I'm retired and I'm drawing $2,000 in my own retirement, I get to keep my full $2,000, but my daughter, if she's found to be a disabled adult child, she can draw $1,000, half of what I'm drawing, and I still get my full amount. And then when I pass away, that goes up to 75% of my benefit. And that would be on the work record of the highest earner parent, if that makes sense. So if I retire first and then later her dad starts drawing retirement and his benefit is greater, which it is, then she'll switch to his work record. Okay, so that is such a valuable benefit, and we want to prove that the disability existed before the age of 22. The easiest way to make sure that is established in Social Security records is to qualify for disability, SSI or SSDI before age 22. So that I think is a great reason why you do want to consider applying for disability benefits. How do you apply? You can call the local office. There is a local office number that you can find in Office Locator. Otherwise, you may be on hold for a very long time on the 1-800 number. You can apply online, which it works very well. So socialsecurity.gov lets you do that. You can use an attorney to help you apply. Now, do you need an attorney? It depends on your situation, and we'll go through this. If at the end of our presentation today, you feel like my child is going to qualify easily based on what I learned today, then you probably don't need an attorney. It's not that difficult. You can do it yourself. But if you're a closer case or you feel like you just want some guidance, someone to help you keep track of the deadlines and the records, you can use an attorney. All attorneys charge the same. They receive 25% of the back pay amount. And so you don't pay the attorney anything up front, but they get paid when the back pay is taken care of. Let me just mention also the Social Security offices are still closed for COVID. And so right now you cannot go into a local office unless you arrange for an appointment, and it has to be a dire emergency. Application would not count as an emergency. Okay, so Social Security disability. When people say I'm getting Social Security or I'm getting disability, a lot of times they're referring to SSDI, which is Social Security Disability Insurance. Now, the amount that someone gets from SSDI is going to be based on work history again, similar to our retirement. And then that person who receives SSDI is also going to be eligible for Medicare after a waiting period. It takes a couple of years for that to kick in after the benefits start. Medically, you have to be medically determined to be disabled and technically eligible. So there's two parts to qualifying for Social Security disability. The medical qualification is the same if it's a child who's disabled or an adult who's disabled. No. Let me back up. It's different. Sorry, it is different for a child versus an adult. So if it is a child who's applying for disability, then the Social Security office is going to look at whether or not there's a physical or mental impairment that results in marked and severe functional limitations, and it's something that's going to last at least a year or result in death. This kind of definition is similar to what you're seeing in special education criteria in all over our state. There are 6 domains. If you have a child who's applying for disability and you think they might qualify and you need some more information about these different domains, feel free to call me and I'll just talk you through it. But basically, you have to have either a very severe limitation in one of these areas or a marked limitation in 2. Now, the disability determination is made not in our local office, but in Austin at an office called Disability Determination Services. And that is where they will evaluate medical records for a child. They're going to really focus on school records and also the parent reports to determine whether or not your child is disabled under their definitions. Now, once your child becomes an adult, the criteria is different. Now the criteria has more to do with workability. The official language is unable to engage in any substantial gainful activity because of the same medically determinable physical or mental impairment that is going to last. So substantial means that they can't work more than just a part-time job. So someone who is working a substantial amount, they're working a full-time job or close to it. Gainful means that they're earning a certain amount of money. In 2021, someone is considered to be earning a gainful amount, substantial gainful activity amount, if they can earn $1,310 a month. Now, for someone who is blind, they can earn a higher amount and still be considered disabled. But if you can earn that amount of money, that's a gainful amount of money, and that it means that you're not disabled under Social Security definition. So and the activity, by the way, I didn't mention, just meant that you're earning it. You're doing something to get that money. It's not royalty payments or something just coming to you. Okay, so there is a 5-step evaluation to determine disability. First of all, Social Security office looks to see if the claimant is working. And again, this is the SGA level. So right off the bat, let me emphasize this again. If your child applies for disability and they are earning over $1,310 a month, then they are ineligible for benefits. So you're eliminated right then. Assuming your child is not working, and I want to come back, I'm going to talk a little bit more about working. I don't want you to get the idea from me that you shouldn't have your child work. So let me just say that off the top. If your child is capable of working that amount of full-time work and earning a good living, you should celebrate that. That's much better than qualifying for benefits. And there are a lot of work programs that let your child try to work and still qualify for benefits. We'll get into those briefly a little bit later. Okay, let's go back to this evaluation. So is the claimant working? If they're not earning SGA level of income, then we look to see, is their medical condition severe? So this can't be something that's just passing, not a very significant disability. If it's severe, we go to the next step. Does the medical condition meet or medically equal a listing? Now, a listing, this is something really important for us to understand. There is something called the Disability Evaluation under Social Security Manual, and the shorthand is the Blue Book. So if you were to Google SSA Blue Book, you would see a bunch of listings, and the listings tell us what we need to show Social Security to demonstrate that our children are disabled. And I'm sorry to just assume we're talking about children here, but since I think most of the people on this call are parents. I'll just sort of speak in those terms. So for example, my daughter has an intellectual disability. So I can go to the Blue Book and look at the criteria to see exactly how she would qualify for disability based on an intellectual disorder is how they word it. And it's got great detail of what the IQ score should be and what other evidence I need to show. For example, I can show that she's having a hard time remembering information, concentrating. And so it will be a combination of her IQ testing and some medical records, some school records. Those kinds of records will help qualify her. And we can do this for all of the different diagnoses that are listed in that Blue Book. So if your child has autism, you can go look up the Blue Book and see exactly what the disability determination services, what they're going to be looking for to determine if your child is disabled. Same thing with Down syndrome. So many of the diagnoses that our children have are included in this Blue Book, and I encourage you to look at that. Now, if you go look that up and you think, oh dear, my child has autism, but he doesn't quite qualify under a listing, that doesn't mean your child won't qualify for disability. It just means it's not going to be an automatic approval. It means we're going to have to look at more evidence. And the next step is determining whether or not the person who's applying for disability can do previous work. So this is going to apply more, someone like me, if I become disabled, then my case is going to be evaluated to see if I can do the same job that I used to do before I was disabled, any job I used to do. And then number 5 is where it gets pretty significant for those who don't have a great work history. Social Security Administration is going to determine whether or not the claimant can do other work, so any work in the community. And this is where we often have to go to a hearing in front of an administrative law judge, where we have a vocational expert to explain what jobs might be appropriate for this person, and we determine whether or not they could, have those jobs. Okay, so that is the medical determination. As I mentioned, it's not just, you need to be more than just medically qualified to get disability. You also have to be technically eligible. The technical eligibility for SSDI has to do with work credits. So you'll see this chart that I have on the screen. For someone who's older and applying for disability, they need about 10 years worth of work credits to qualify. For someone who is younger, look at that first line, age 21 to 24, you actually only need about 1.5 years worth of work credits to qualify for SSDI. Now, what about people who don't have those work credits? Maybe like my daughter, she was never able to work enough to get those credits, or I was a stay-at-home parent for 10 years, so I'm just recently been able to get my credits. Or maybe you're a teacher or someone who doesn't participate in the Social Security system. If you're in that situation, then you're not going to have the credits to qualify for SSDI. And just a reminder again, childhood disability benefits, the disabled adult child who doesn't have his or her own work credits may be able to tap into a parent's work record. So that is a great program for somebody like my daughter who wasn't able to get her own work history up. Okay, going back to, so if you don't have enough work credits, then the first letter that's probably going to come in the mail after you apply is a letter saying, I'm sorry, but you're not going to receive disability benefits because you haven't worked long enough. This is called a technical denial. And a lot of people get overwhelmed with this because they get that letter and they think, oh my goodness, my child has such significant disabilities. This is a mistake. But if you read that letter carefully, it may be just referring to the credit aspect for SSDI. So remember, there are insurance benefits under Title II, and then there are needs-based benefits. So if your child or you don't have enough work credits, then you switch over to the other program under Title 16, and that is SSI, full name, Supplemental Security Income. Now, this program There is a monthly payment, just like SSDI, but this time it is a set amount. It's not based on work history because we don't have work history. In 2021, the maximum SSI payment is $794 a month for an individual. Along with SSI, in Texas, we qualify automatically for Medicaid. So if your child qualifies for SSI, Medicaid is going to kick in. And that's going to be immediate, by the way. You don't have to wait a couple of years for that to kick in. For SSI, there are some non-financial requirements. You do need to be a citizen or lawful resident, and there are a few other exceptions. But that is not true of SSDI. You can live outside of the US and still collect SSDI, but not so with SSI. But the main criteria are very similar. The medical determination for SSI is just the same as for SSDI. I say just the same, there's a few tiny differences. You can maybe get qualified for presumptive disability or presumptive blindness payments. Those are quicker qualifications under SSI, but basically they're going to be the same for the medical determination. What is different is the technical eligibility. Remember, SSI is a needs-based program designed to provide basic food and shelter. So to qualify for SSI, you have to be needy. You have to be poor. So Social Security Administration is going to look at your income and assets to determine whether or not you qualify. All right, let's look at the income. There's 4 types of income that Social Security counts for SSI. There's earned income, unearned income. Then this is the funny type of income. It's called in-kind support and maintenance, and then deemed income. Unearned income. Let's look at that first. Excuse me. We look at unearned income, and Social Security Administration will take what you're receiving as unearned income and deduct it dollar for dollar, other than they give you the first $20. We call it a $20 disregard. So what that means is if there is a pension coming in, or there's an IRA payment, or someone gives a gift, then that, or say you have a car accident and there's money coming in from that, a settlement, something like that, then that is going to be deducted dollar for dollar from the amount of SSI that you qualify for. So it's important to remember IRS stimulus checks, tax returns don't count as income. So let me give you a better example. Say child support. We're going to talk about child support a little bit briefly in just a minute, but child support, if someone is over the age of 18 and there is lifetime child support, that is considered income to the beneficiary. Even though a parent may be getting the check, it is income to the beneficiary once that child has hit the age of 18 and now they're an adult disabled child. So that means if someone receives $500 worth of child support, then Social Security Administration is going to start with the award of SSI and subtract $500 every single month as unearned income, and that will reduce the benefit. There are ways around that with a special needs trust, and we can talk more about that. If you have questions on that issue, feel free to call my office or email me, and we'll talk more about that in greater detail. Okay, oh, here I have an example. So if you have a $500 gift, if say grandma leaves $500 in her will to my daughter, then I can disregard the first $20, but I have to report the gift, and my daughter's check is going to be reduced the next month by the remaining $480. So instead of $794, that next month she's going to get $314. All right, we'll move on to earned income. Okay, this seems obvious. We know what earned income is. It's when we're working and getting wages, and those must be reported to the Social Security Administration if you're receiving SSI. The Social Security Administration is going to let you keep the first $65 of earned income. They're not going to reduce your check for the first $65. They're also, now, if you haven't used up that $20 disregard on any unearned income, you also get to keep that $20. So if the only income that is coming in is from wages, you get the first 85. After that, the SSI benefits will be reduced $1 for every $2 earned over that amount. So I'll give you an example on this one. If my daughter earns $485 in a month, then she has to report that to Social Security by the 10th day of the next month. So in April, if she earns $485, I've got to tell Social Security by May 10th. And if she doesn't have any other income, then we're going to disregard the first $20. She gets to keep the next $65 because it's earned income. And then half of the remaining gets reduced. So that's another $200. So instead of her check being $794, her next check will be $594. And so sometimes when our children are working and earning different amounts, then the checks may vary in the amounts. But remember that Social Security is only taking half of the benefit, half of the wage amount as a penalty. They want to encourage our children, encourage us if we're on SSI to work. And so they make it easy for us to end up with more money if we're working. Now, let me just remind you, if my daughter is earning $1,310, now she's earning so much that she's not going to be considered disabled anymore. And I say that again, there are a lot of work incentive programs. So if your child is already on SSI and wants to try to work, then I encourage you to try. And there are ways where we can hold off on the penalties. We'll get into that briefly in a minute. Oh, and this was just to emphasize that anytime someone is working and receiving SSI, they are going to have more income in the end. Okay. Wage reporting. How do you report your wages? I mentioned you've got to report it. It can be done on your My Social Security account. There's an app to report. We used to be able to go into the Social Security office, but now obviously we can't do that. But you can call the main teleservice center, or you can mail or fax in the information. I would say anytime you mail something to Social Security office, I would use certified mail, get a return receipt request, the green card, have that signed, because Social Security is notorious for losing mail. So, but that's the way that I personally report my daughter's wages, is by mail, so I have a record of it. But there are apps and things like that. Okay, let's talk about ISM income. In-kind support and maintenance, known as ISM, is food or shelter that somebody else provides for you. So this is a situation where my daughter lives in my house for free. If I'm not charging her anything for room and board, I'm not making her pay the bills, I'm just giving her all the food, paying the bills, giving her a place to live, that is actually considered income to her, and it's referred to as ISM. The general rule is if your child is receiving ISM, there's going to be a 1/3 reduction in the SSI benefit. There's slight variation. If someone is living at home for free, then it's the value of the 1/3 rule. That's a 1/3 reduction. And so that means instead of $794 in 2021, they would get about $530. That is a little bit different from having a special needs trust pay for housing. There's a $20 difference. So instead of $530, that child would get $510 as their starting value for SSI. Okay. And there are ways around that also we'll get to in just a few minutes. Deemed income, that's the last kind of income we need to talk about. That just means that a spouse's income counts for the other spouse. And a parent's income counts for a child under the age of 18 if the parent is living in the home. Excuse me. So what that means is if I have a young child, say 10 years old, and I go to apply for disability for that child, my income will count and my assets will count. We'll see also. So what that in effect means is many of our kids are not going to qualify for SSI until they hit the age of 18. Because at that time, now parents' income, parents' assets, doesn't matter. We just look at the adult child. Okay, I mentioned this before, and this could be a whole nother hour-long presentation, but let me just remind us that I just don't want you to have the impression that I'm saying your child should not work. There are a lot of work incentives in the Social Security Administration. Once your child is receiving benefits, the Social Security Administration has a philosophy that we want to encourage our kids to try to work, to try to earn some money, see if they can eventually get off of these benefits, or if not, let them work part-time. And so there are a lot of programs that encourage that and make it easy for us to let our kids try to work. One of those programs is the student earned income exclusion. If your child is under the age of 22 and regularly attending school, your child can earn up to $1,930 a month. There is a cap on the year, and that does not count as income. In other words, if you have a child trying a work program, maybe they're in a post-grad program and they're out earning a little bit, as long as you report to Social Security that your child who is receiving SSI is actually a full-time student, then Social Security won't reduce their check until they hit the age of 22. Okay. And you can see there that in college, it needs to be you need to be in college at least 8 hours a week. Otherwise, it's pretty much 12 hours per week. Okay. Another work incentive is something called impairment related work expenses, or we call that IRWE. That is where Social Security Administration can exclude out-of-pocket expenses for items and services that are related to the disability and that are needed so that your child can work. So for example, if my daughter can't catch the VIA and she needs to take an Uber to her job because we're not in the VIA area, then I can actually gather up all the transportation receipts, the Uber receipts, turn those in and say she has no way to get to work if she's not using this means of transportation. Or if she needs certain medicine, if she would not be able to work unless she had this medicine, then I can show how much she pays for her medicine every month. And that can be reduced from her earnings through this impairment related work expenses. It's a process that you need to get these expenses approved by Social Security, and there's a form to do that. If you have questions, call me and I can walk you through that. Okay, there are also other programs. We won't get into a lot of detail on these others, but Plan to Achieve Self-Support. That's where the person receiving SSI comes up with their own special, specific individual program where they have work goals and they have timetables, and it allows them to earn money and not have it affect their SSI. Call me if you have questions about those work incentives. Like I said, there's a lot more detail we could go into, but we don't have time today. Okay, besides income, to qualify for SSI, you must have limited resources. Resource is the term that the Social Security Administration uses for assets. So a resource is anything that can be converted to cash unless it's excluded by law. So what that means is if there's a 529 plan or a whole life insurance plan, if the person receiving SSI has the ability to say, I want to cash that out, I want to draw that money, then it is an asset. It's a resource for them and it will be counted. So all of the resources for the individual receiving SSI total together have to be less than $2,000 for an individual. And that's going to be measured on the first day of the month. And we already mentioned, parents' resources count for minor children and spouses' resources count. So what that means is if my daughter is receiving SSI and she's getting a check for $794 every month, then the first day of every single month, she is not eligible unless all of her bank accounts totaled together have a balance of less than $2,000. So if your child receives SSI, you can't just let it grow and grow and grow. You're getting that because it's a needs-based benefit. And Social Security has the opinion, if you have more than $2,000 in the bank, you don't need it this month. And so you've got to make sure that the bank accounts stay below 2,000. There are exceptions. Besides the first 2,000, someone receiving SSI can have a home. They can have a car. They can have all the furniture and appliances in the home that they need. And you can also have a life insurance if the face value is less than $1,500. You can have a prepaid funeral or burial plot. You can keep some funds up to 9 months if it's, back pay for SSI or SSDI. And then here are the big exceptions. You can have a special needs trust and an ABLE account. All of the money in that special needs trust is not going to count towards that 2,000. Someone could have a special needs trust with $1 million. If only we could have $1 million in our trust. But it doesn't matter how much is in there, it won't count for purposes of eligibility for SSI. ABLE account, you can have up to $100,000 in an ABLE account and it won't disqualify someone from SSI. I do want to mention, and again, this is something we could talk about for hours, but a special needs trust is not just a regular trust. So if you want to have funds accumulating and being saved, set aside for your child, it needs to be a specific type of trust, must qualify as a special needs trust. That is a trust only available for someone who is disabled. The beneficiary control is very restricted, and it's not a support trust. So that means it's not the type of trust where your child is going to get income payments every month. They can't even go to the bank and just say, hey, I want to withdraw. Basically, the trustee pays for things. And it's a great idea to have a special needs trust. My guess is if you're listening to this program for a child, you probably want to learn more about special needs trust. And the amount in there will not be countable for SSI purposes. There are two types of special needs trusts that you need to know about. A first party trust has a Medicaid payback. What that means is one day when the beneficiary of the trust passes away, if there's any money left in that trust and it's a first party special needs trust, Medicaid is entitled to be reimbursed for whatever they've paid for your child over all the years from in every state they've lived in, up to the amount of money left in the trust when your child passes. That is a first party trust. The kind of trust that most of us want to make sure we have in place is a third party special needs trust that does not have a Medicaid payback. That's funded by third parties. So me as a parent, I fund it for my daughter, Angela, and then I can say who gets the remaining funds when my daughter passes away. So it will go to, her siblings in my case. So why would anybody want a first party special needs trust? If the money is already in the name of the person with the disabilities, so they have legal ownership of the funds, that's the only kind of special needs trust they can use. And I just mentioned that, again, we could talk forever, but I mention that because it's important to do planning if you have a child who's on SSI, Medicaid, Medicaid waiver programs. You don't want to accidentally disqualify them from these programs by leaving a big inheritance that doesn't go to a special needs trust. And I have so many things I'm tempted to get into, but it's important to set that up. Don't just say, I'm gonna leave the funds to somebody else. Call me if you have questions about that. Okay, but if you do have that situation, say the inheritance, grandma left an inheritance to your child who receives SSI, then what we can do is we can take that money or personal injury settlement or child support or something, and we can move it to the trust to qualify them for SSI. They may lose eligibility for a month or two while the money's being transferred, but we can get them requalified. Okay, child support, I mentioned this briefly earlier. Child support, if you have the lifetime child support, it must be irrevocably assigned to one of those first party special needs trusts with a Medicaid payback. It's the only kind you can use for child support. And it must be done by court order. You can't just take your child support and then move it to the trust if you don't have a court order. And there are some problems with that. The Attorney General's office won't help you in collecting those payments right now. If you're in that situation, please call me because I'm part of a group where we're working very hard to get that law changed. Basically, we all need the Attorney General's office to help in collecting those payments. So again, I would love to hear from you if you have that situation where your child gets lifetime child support. Military survivor benefits, another type of unearned income. Because of the Disabled Military Child Protection Act from a few years ago, SBP or Survivor Benefit Plan can now be irrevocably assigned to a first party special needs trust. Again, it has to be the first party type, but that way the money doesn't count. And I've already mentioned this before, if you get an inheritance that's not directed to the trust, but rather to the individual, then we can transfer it to the trust. A third-party special needs trust, that, as I mentioned earlier, is a trust that's created and funded by any third party, someone other than the individual with the disabilities, and you won't have a Medicaid payback on that type of trust. So that's a little detour to just show you why estate planning is so critical for families with special needs, children. And so basically, if your child is on a government program that is needs-based, meaning we're looking at income and assets, make sure you talk to a planner so that you don't accidentally disqualify your child for benefits or force funds to go to a first-party trust with a Medicaid payback. Okay. I think I've talked about trust enough. I'm tempted to keep going. All right. ABLE account, we said that is also something where the funds don't count as a resource for SSI and Medicaid purposes. These are pretty new types of accounts. In Texas, we just got ours up and running a couple of years ago. And this is an online savings account for individuals who are disabled before the age of 26. There is a limit on how much can go into an ABLE account. It can only be $15,000 a year, and that's total. So not just from one person, but from everyone who contributes, it's $15,000 total. If your child has an ABLE account and they're working, you can add some extra money from their wages, another $12,000 plus. Again, you can have up to a $100,000 limit if you're receiving SSI and the money won't count. You can have a lot more if your child is only on Medicaid, but do not have $100,000 in your ABLE account, because the ABLE accounts also have a Medicaid payback. So this is not something that replaces a third-party trust, because when your child passes away, we've got Medicaid coming in and asking to be reimbursed. It's not quite as severe of a payback as the trust. For example, we only look at Medicaid payments after the ABLE account was established, but it's still, a lot of times we don't want to get into that. So you can avoid that by using a third-party special needs trust rather than donating to an ABLE account every year. One great thing about the ABLE accounts, though, is that they can be used to eliminate in-kind support and maintenance charges. So if you remember, we talked about the SSI being reduced because someone lives at home for free. Your child is just getting free food, free shelter, and that's an ISM penalty, which reduces the benefit by about 1/3. Oh yeah, here's my reminder slide. Basically, again, about a 1/3 reduction from the maximum rate. But if you have your child pay their fair share of the bills in the house, then there's not going to be an ISM penalty. So the thinking is, this is a needs-based program. So if someone can live at home for free and they don't have to pay anything, they don't need as much money. So what you want to show Social Security is, well, actually my child is paying their fair share in our home. They're not living for free. They're contributing to the expenses, to the food bill, the electricity bill, the water bill. And if you can show that, then the penalty will go away. Now, what do they need to contribute to? What's their fair share need? What does it need to go towards? It needs to go towards these 10 items. So you see things like electricity, water, sewer, garbage. Notice that it's not every single expense. There's no cell phone bill. There's no cable bill. Those are not included in the 10 items. But if you want your child to get the maximum SSI, what you do is you give these statements, you show Social Security Administration these bills, and you total them up and you show what your child's fair share is, and you have them start to pay it. So we'll do another example. If Maria is living at home with her parents and there is rent every month for $850 for the family, then what Maria's parents would do, her representative payee, her representative would go to Social Security office and explain that here's our rent payments. I'm going to show you proof of that. Here's our electric bill. Here's our water bill, our garbage. And we spend about $475 in food. If you add that up, it's $1,500. And so you show Social Security that her fair share would be $500 if there are 3 people living in the house. So basically you total everything up, figure out how many people are living in the house, and figure out the pro rata share of the person receiving SSI. You report that to Social Security, and again, it will make the ISM penalty go away. But what happens if the person getting SSI doesn't get enough money to pay their fair share? Say the mortgage is so high that they don't have enough money to pay that. There are some ways around that too. You can show that you're in a public assistance household. You can make a loan of the ISM. Sometimes this works if someone's applying and waiting for money to come in. Number 3 is very common. You can sign a lease agreement with your child. That is a very common approach where you enter into a contract with your child and have them pay their fair share of, well, not their, you set up an amount, you say, this would be the market rent that I would charge someone who wasn't my child. So every month you're going to pay me that and you'll get room and board. Now, I'm not a huge fan of number 3 because first of all, it doesn't work in all situations. If your child's under a guardianship, I think it's not appropriate for a guardian to be signing a contract and, signing it as a parent and then on behalf of the child. So that's problematic. But even more so, I think the income under these lease agreements is most likely considered income. I'm not a tax person, but I think you would need to include that in your tax returns and pay income tax on the lease payments that you receive. And also, if you're trying to claim your child as a dependent, I don't think you can have them be a boarder and still say they're dependent. So number 3 is not my favorite way to do it. I much prefer using an ABLE account. Now, the ABLE account option, remember, is only available if your child was disabled before the age of 26. That law may change. It may become a higher age down the road, but right now it's age 26. And the way to understand how the ABLE account option works for removing ISM is you have to understand that anyone who donates funds to an ABLE account, whether it is the wages of the person who's working and has the ABLE account, a parent, a grandparent, whoever donates to the ABLE account, once the money's in there, it is considered to belong to the beneficiary of the account. So I can donate $1,000 to my daughter's ABLE account. The second it's in her ABLE account, it's her money. Her special needs trust could move funds into her ABLE account. Once it's in there, it's in her money. So once she has money in her ABLE account, those funds can be used to pay for any kind of qualified disability expense. And by IRS regulations, this includes housing. So once the money's in the ABLE account, it can be used to pay for her housing. So you can see when someone doesn't have enough money that they receive in their regular monthly SSI to pay their fair share, they can pay the rest of it from an ABLE account. Let me give you an example of this one. Okay, so now let's say Maria is living at home with her parents, but her fair share is $900 a month. So she doesn't get enough SSI to cover it. She can report to the Social Security Administration that she's going to pay $500 in SSI from her SSI money, and the extra $400 will come from the ABLE account. And if she does that, the ISM is removed and she gets the maximum SSI. Now, let me just say, it's not enough to just get it approved. You have to actually do it. You can't say, hey, she's going to pay $400 from her ABLE account, $500 from SSI, and then you never take the money. You need to actually every month go into the ABLE account and transfer it to your account or write a check and, make sure that you actually do what Social Security, what you told them you're going to do. Otherwise, you could be assessed an overpayment down the road for her being paid too much because she wasn't following the plan. Okay, that was kind of overload of information. Let me pause for a minute. I've got some more things to go through with appealing, but are there any questions that we should answer right now?
Yeah, there was one question. It came through in Spanish, but Mary Alice had translated it for me. The question is, if my son is legally blind, can he receive Social Security, and how much would he receive as a minor?
Okay, So that's a great question. If someone is legally blind, they will almost certainly qualify medically to receive Social Security disability. But whether or not they can get those disability payments, you go back to that analysis of, first of all, your child probably hasn't worked. So is there a parent in the home who is drawing their own Social Security retirement or Social Security disability, or a parent who is deceased? If that's the case, then they'll probably qualify for benefits, probably as a minor rather than being disabled. But if that's not the case, then that child is evaluated under SSI, okay? Because there's not a work record that that child can get benefits from. So now we look at the SSI rules, and if it's a minor child, we have to count the parent's income and the parent's assets. So some things don't count. For example, one home, one car, but say if the parents have two cars, that child's not going to get any benefits until they hit age 18. Because remember, we're going to look at income, we're going to look at assets, and all of that is going to be evaluated to see if someone qualifies, and a parent's income and assets count for a minor child. So there are situations where parents' income is very minimal and their assets are minimal, and children do qualify. And if you have that situation, call me and we can walk through your specifics and figure out if you might qualify. But if there's, two parents earning money, significant assets, couple of cars, then they probably won't qualify. I hope that answered the question. Anything else? Any other questions?
There's one more that just came through. It says, I'm my father's POA. He is disabled. Do we qualify to do this for him?
Yes. Now, the Social Security Administration actually does not like powers of attorney. So the fact that you're the POA doesn't really, you can't just take care of it for him, but you should definitely apply if you're, yes, I'm talking in terms of children, but this is standard. So again, what would happen if you applied with your father? He might have to sign the paperwork or himself, or sometimes guardians can sign. But anyway, you get the application in, and the first thing that would be evaluated is, does he have a work record? So if I were looking for my father, the first thing I would do is go online and create an account on ssa.gov and try to see what his work credits are. You'll be able to tell right by looking at that record, is he going to qualify for Social Security disability insurance? If so, then he can apply for disability, and it'll tell you exactly what he would get. And his case would be evaluated medically the same way that we covered earlier. We would look to see if his disability meets a listing. Does his disability qualify him automatically? If not, could he do a job he used to do, or could he do other work? And so call me if you want me to walk you through that. But yes, for sure, that is the most common type of application, is someone who's older. Now, once someone hits the age of 65, they are considered disabled per se in Social Security world. So if they don't qualify for a retirement off of a work record, then they can get SSI once they're over age 65. That's an easy qualification if they have limited income and limited assets. So again, someone who's over 65 and they don't have a work record, and if they're going to get SSI, they have to have less than $2,000 in total resources, not counting, the one home, one car, all those exceptions. Okay. Any other questions?
All right. There's two questions about your contact info. I'm assuming it'll be at the end of the presentation.
It will. It'll be at the end of the, yeah, it is Alison at packardfirm.com. Alison has one L, A-L-I-S-O-N, but I'll have a slide at the very end. Okay, let's keep going. All right.
Just a sec. The interpreter asked for a quick break. Could we take just a few minutes just to regroup and then come back in about 5 minutes?
Absolutely. All right. We'll see y'all in 5 minutes.
Fantastic. Thank you so much. All right, if the interpreter is good to go, Allison, then we are good to get back started. Yes? Okay, fantastic.
Okay, great. All right. I have just a few more issues I want to touch on, and then I'll save time for plenty of other questions. So feel free to submit your questions, and we'll cover those in just a few more minutes as I get through some last slides. Okay. What happens when you apply for SSI, SSDI, and you're denied and you think this is not right? This is very, very common. You should know that. And appeals are worth considering. What that means is if your child is denied for SSI, for example, what that's saying is Social Security couldn't make a determination based on the medical records, based on the information that you gave them. It doesn't mean that your child won't eventually qualify, but it means they don't have the evidence that qualifies that child right now. So I would consider appealing it. The first step is a request for reconsideration. And by the way, this kind of appeal, I mentioned the medical issue, but it could be any issue. Say you are submitting some information to the Social Security Administration to have the ISM penalty removed, and they say, nope, your child's going to get $530 a month. And you're thinking, no, I gave you all this information. It should be $794. Then you can appeal that. So whatever determination is made by the Social Security Administration, if you think it's wrong, you have the right to appeal it. Your first step is a request for reconsideration. That's a certain form that you would fill out, and there's different boxes that you can check. You can ask for a case review, an informal conference, or a formal conference. Now, if you read the form carefully, you'll see that case review is the only option you have if it's a medical determination. So basically, you know, if you get a letter saying that your child did not qualify for SSI benefits because they were not disabled, they didn't meet the criteria, then you can appeal it and ask for a case review. What that means is someone's going to go back and look at all the evidence again, somebody different, to see if they agree with the person who initially determined ineligibility. Now, if your issue has to do with ISM, or if whether or not a special needs trust qualifies, or something other than the medical issue, then you can also ask for an informal conference or a formal conference. Anytime you appeal, you have 60 days to appeal. And if you do it quickly, if your child is already receiving SSI, for example, and then you get a notice that the benefits are stopping, if you do it quickly within 10 days, then the benefits continue. So even though you have 60 days to appeal, you want to jump on it quickly, especially if there's a reduction or a termination of benefits. Again, the case review is an option for all types of cases, and someone will review the file. You can also submit new evidence. So if you think, oh, my child's case was denied, but oh my goodness, I realized the neurologist didn't give the records, then you could turn in the neurology records. And then there will be a reconsidered determination. Now, I will warn you, most of the time, it's going to be the same. Okay, if you have that situation where there's a missing record, you find out, you just need to get that in, you might be one of the lucky ones to have a new decision issued, but most of the time it's going to confirm the denial. That is not true if you ask for an informal conference. If you are talking about a financial issue, a lot of times if you can get to a conference and actually talk to someone and figure out together what is missing, you can get that corrected. But asking for an informal conference is the exception. Most denials are because of medical ineligibility. And so most of the time that Social Security office receives an appeal, it's going to be that simple case review. So if you fill out this request for reconsideration and it's a financial issue, ask for an informal conference, and then you will be able to get in there and talk to somebody and work it out. But make sure you really emphasize your choice. I mean, when I do it for somebody, I circle it or highlight it, and make sure they know we want a conference. Don't just give this to somebody else to look at. I want to talk to you. Formal conferences are also available where you can subpoena adverse witnesses and documents. I think informal conference, I tend to be able to get most of the issues resolved informally, but that is also an option. Okay, if the request for reconsideration unfortunately doesn't change the outcome, your next step is to appeal to an administrative law judge. This is where you're saying, I want a hearing on this issue. And again, this is actually very common. And so don't be afraid to do this. So an example would be an individual who has autism. Just the diagnosis of autism is not going to tell the Social Security Administration whether or not that child qualifies for disability payments. And so what you would do is, if my child has autism, I am going to look at the Blue Book and try to give as much evidence that the Blue Book is asking for. But what if I don't qualify under that Blue Book terms? I might need to go to a hearing and give more evidence to the judge. For example, if I went to a hearing and said, my child tried to work when he was right out of high school. We tried this program with Texas Workforce Solutions, and it worked for a while, and then he lost that job. And then we did this, and then we did that. And let me tell you more about my child. Then a lot of these cases actually are approved at the hearing level, because that is where the judge is going to be able to hear testimony of stories, of more details about the person applying. And so don't be afraid to appeal to an administrative law judge. Ask for a hearing. Now, you can do this without a lawyer. I would say if you're denied the first couple of times, it's probably time to get an attorney. I know I'm an attorney, but you don't have to, but I would recommend getting an attorney and letting them help you hopefully win this appeal. Okay. Again, I mentioned the appeals can be for medical or technical denials. And this is a picture of our local Office of Disability Adjudication and Review. That is where we have these hearings. Well, right now they're over Zoom, but one day when we go back, that's actually the building in San Antonio near 410 and well, it's Isom Road, near that area, near the office. Okay. So, and by the way, that's my beautiful daughter giving a thumbs up. All right. Social Security timeline. You need to know if you're going to have to go through this appeals process, it is going to be a long process. When you file an application, it will probably take 3 or 4 months just to get the first answer. You might get the quick answer for SSDI, meaning your child doesn't have enough work credits. That might come pretty quickly, but the determination for SSI typically takes 3 to 4 months. And that's because when you apply, you're going to fill out a lot of forms and explain who all the doctors are, hospitals, and then the Social Security Office Disability Determination Services is going to order all of those medical records. So it takes a while to get those records in. It takes a while to get the case evaluated. So it will be a few months before you get your answer. If the answer is no, this person doesn't qualify, then the reconsideration, that's that first step in the appeal, is going to take another at least couple months. Maybe you'll be lucky and be surprised it comes more quickly, but unfortunately it's usually 2, 3, 4 months just to get a letter saying, hey, we looked at it and we think we were right the first time. So it's not a quick situation. If you're trying to have an informal conference, you would set that up. Those can be done by Zoom in the days of COVID, but they're supposed to have someone that will contact you. My experience has been we usually contact the Social Security Administration and remind them that we need a conference set up. If that doesn't go well, if you can't get the case resolved on that reconsideration level, then you go to the hearing level. And unfortunately, that is going to be many, many months, maybe a year before you get your hearing. There is, I was going to show you, in San Antonio, we're pretty good. This is based on the fiscal year 2021. So this is the most recent data. In San Antonio area, it's about 288 days from the time you ask for your appeal until you get your hearing. I don't know if that's accurate, but that's the official data. But San Antonio is not as bad as other areas. If you're in Dallas, you're waiting a lot longer. There are some payments that can come quickly while you're waiting for a determination to be made. I alluded to this earlier. There's something called presumptive disability and presumptive blindness. And if you can see this slide, there are these 15 qualifications if you have an amputation of your leg at the hip level, total deafness, total blindness. It's got some common situations for our kids: cerebral palsy, Down syndrome, intellectual disability. If, for example, your child has an intellectual disability and they have complete inability to perform basic self-care activities, that's toileting, eating, dressing, then they might qualify for presumptive disability, and then the payments will come much more quickly. If you get presumptive disability payments, it means you're going to get payments for 6 months. And if the final determination is different, if you don't qualify, surprisingly, you actually don't have to pay those payments back. But again, the Social Security office will work with you. We see this a lot with very premature children who have very low birth weights when they're born, and maybe the parents are in desperate need of Medicaid, and so they can qualify quickly for the SSI for that child with very low birth weight, and then that lets Medicaid kick in to help with some payments. Okay, if you go all the way to a hearing and then the judge unfortunately does not say that the child qualifies for disability, you can appeal to a higher level. And by the way, that determination from the judge might take a few months. Even though you've had your hearing, it doesn't mean you find out that day, unfortunately. But when you get the letter, if it's not what you want, you can appeal to what's called an appeals council, and you can go all the way to federal court. Sometimes at that point, it's worth having a conversation of, do you want to invest this much money? Do you want to go forward, or would you rather just start over and file a new application? A lot of times we just start over. We say, okay, let's get better medical testimony. Since we started this process, maybe the child has tried to work and not been successful. We have more evidence, and we can look at the situation. We can appeal it, but a lot of times we file another application. Just because your child doesn't qualify at age 18 for SSI does not mean they may not qualify down the road. Sometimes the judges want to see evidence of attempts at work. The judge may say, well, I don't know if your child can work or not because you've never tried. And so it could be that, while an initial application is denied, it might be approved a little later down the road. But remember, if you're going to do that, age 22, to make life easy to qualify as a disabled adult child, you do want that determination made of disability before the child is 22, because that's going to open the door to benefits under the parent's work record if your child does not get married and is never able to work a good full-time job. Okay. What happens if you get a notice of overpayment? And this is common in the world of Social Security. This is where you get a letter that says, hey, we paid you too much. So I'll give you an example. If you said, I'm going to use the ABLE account to pay fair share expenses and my child's going to pay me, and then Social Security goes in and they look at the ABLE account because they can see what's happening there. And if they say, oh my goodness, I noticed from a year ago that your child was not paying his share from the ABLE account, they can send a letter saying we overpaid you and you need to pay us back that ISM amount. Or say, Social Security might find a, I don't know, they might look at bank records and see that the bank account was over $2,000 for 4 months. And if they go, and this is not something where they have to catch it right away. They could be doing a case review and notice that the SSI account, just a regular bank account, not a special needs trust, not an ABLE account, but the regular bank account had funds in excess of $2,000. If they notice that, then they can say, well, you were overpaid. You were ineligible for any payment during month A, B, C, and D. So you owe us all that money back. And they will send you a notice of overpayment. So those are letters that you've got to take seriously. Do not ignore them. You've got to figure out what the cause is. Why are you being assessed this overpayment? Is it because there was a change in your living arrangement? So again, let's go back to the ISM example. If I say there are 4 people living in my house and then one of my kids heads off to college, I have to notify Social Security that now there are 3 people living in the house and make sure that that doesn't change anything. And that is very important if your child is a minor and getting benefits, because remember, income and assets of the parents count, and also the size of the family makes a difference on, you know, what those income and asset levels can be to qualify for payments. So you've always got to report changes in living arrangements, changes in family composition, you know, marriages, divorces, people moving into the house, moving out of the house, excess income or resources. This is really important. I can't emphasize this enough. If your child receives money, say, you know, grandma left an inheritance, or there was a little car accident and everyone in the family got a $20,000 payment for being a little banged up in the car accident. You know, once your child who receives SSI, or you if you receive SSI, once you get income or have a new asset, you've got to report that to the Social Security office. If you don't, you're asking for an overpayment problem down the road. You also are supposed to report if your child is no longer disabled. Work, you have to report work. And then also, another reason there are overpayment errors is maybe you're appealing and you appealed so quickly that they didn't stop the benefits, but then you lost the appeal. You will have to pay the money back. So you can keep it so the benefits are coming in, which is usually a good idea because we don't want to lose the Medicaid. But if you lose your appeal, you will have to pay the Social Security benefits back, the SSI payments back. Sometimes there's an error made by Social Security. So you want to just look, you want to make sure you look at the letter and carefully evaluate whether or not this overpayment is accurate. Remember, if the overpayment is not accurate, if you say, no way, I reported this, or this is not right, then you can go back to all those appeal options. You can, you know, file a request for reconsideration on the overpayment. If it's still denied, then you can ask for, you know, you can ask for an informal conference. You can go all the way to a hearing on these issues. So, you know, make sure you read the letters carefully. If the overpayment happens, besides appealing, you can, in some situations, ask for a waiver. Now, a waiver is pretty tough. Let me just touch on these other kinds. You can ask for a payment plan, you can ask for a compromise, or you could file for bankruptcy. Okay, let's talk about the waiver first. Waivers are tough to get. To get a waiver of the overpayment, you have to show that you cannot afford to repay this payment. And also, the overpayment was not your fault. So this is tough. You basically have to say something like, I reported this. Here's my green card proof of, you know, that you received it, my receipt that the mail got to you. And it was not my fault that you didn't process this information. And by the way, I have to keep all of my SSI. You know, I need it to live. I'm not going to make it. So in that situation, sometimes a waiver is issued. But again, it's pretty rare. More common might be a payment plan. You can negotiate with the Social Security Administration to pay less than the full amount. If you're receiving SSI, they will automatically offer you to be able to return that overpayment amount at 10% reduction in the benefits. So let me back up. So what that means is if my daughter's getting $794 and she has an overpayment, no matter what the amount is, they'll only reduce her check by 10%. So they'll knock off $79 every month from her check. And it might go on for years and years and years, but because she's on SSI, they won't reduce it more than 10%. Because again, people who receive SSI, they're determined to be needy. They need this money for basic food and shelter. So the Social Security will work with you to slowly pay back the overpayment. There's no interest. So it's a good deal that way. If the person with an overpayment is receiving SSDI, you're going to have to negotiate, okay? Because if you're receiving SSDI, you're not determined to be in need the same way as if you receive SSI. So you'll have to negotiate the amount of money that's withheld from the check. Otherwise, if it's SSDI, they can just stop your benefits until you pay it back. So you want to get right on top of this. work with the Social Security Administration to set up some kind of payment plan. Okay, you can also compromise if there are some legal issues. Sometimes the Social Security Administration will work with you. Typically, you might have to get an attorney involved to get that compromise done, but not all the time. So, strategies to avoid overpayments. You do not want that letter saying you have an overpayment. Now, don't get overwhelmed if you get one, okay? First of all, if you're reporting wages and that wage amount is different all the time, you'll probably get overpayments based on the adjustments that need to happen from earned income. So don't panic. But if you can avoid overpayments, you want to do that. So the way you avoid them, and I know I've mentioned this before, but make sure you report your changes to the Social Security Administration. Don't sit on information that they need to have. Any change in living arrangements, any financial change, you need to report it by the 10th day of the month following a change. So what that means is if you create an ABLE account for your child, you need to report it by the 10th day of the next month after you created it. If you have a special needs trust account, a special needs trust fund that is a special needs trust drafted and funded, you need to get that into Social Security Administration. Let them review the trust. Get that in right away. Any earnings, get those in. And that is the best way to avoid overpayments. A representative payee is someone who is appointed by the Social Security Administration to be able to conduct business on behalf of a beneficiary who is not able to manage their money, basically. So I'm representative payee for my daughter. Now, only one person can be the rep payee, unlike guardians. For those of us who have guardianships, if you have a guardianship of your child, it might be both parents. A rep payee can only be one parent or one individual, but that makes it much, much easier. If the person who's going to receive benefits has clear disabilities, a lot of times the Social Security Administration will work this out with you. They'll know that there needs to be a representative payee. But you should just know that that's something you want to have happen. And by the way, this is a little bit of a detour, but if you do have a child with significant enough disabilities that they need a guardianship, you probably want to just have a guardianship of the person, not guardianship of the estate. In Texas, guardianship of the person can make medical decisions, sign contracts, decide where somebody lives, but managing money is guardian of the estate. However, guardianship of the estate, you're going to end up needing to have an attorney do an accounting every single year. So it gets expensive, and we can usually avoid the guardianship of the estate by making sure someone is managing money in other ways. And so if, for example, there's a big special needs trust, we don't need guardianship of the estate because there's a trustee managing those funds. If someone is receiving Social Security income, supplemental security income or Social Security disability benefits, then you can have a representative payee who has a fiduciary obligation to manage the money, and that avoids the guardianship of the estate. Hope that makes sense. But look into that if it makes life much easier if there's a representative payee. And finally, watch for all the letters from Social Security that come. I know when you get that envelope, it kind of makes you jump, your heart skips a beat, you're scared to open it, like, what is this? But make yourself read that letter front to back, understand it. If you have questions about what it means, call an attorney or call someone at the ARC, get some help making sure you understand what that letter is telling you. If you're being assessed an overpayment, don't just throw it in the drawer and hope to deal with it later. Jump on these things, because by getting ahead, by jumping on the letters, making sure you respond, it minimizes overpayments, it minimizes problems, and it protects the government benefit. It's devastating when unexpectedly SSI or SSDI is terminated. And for a lot of us, it's that Medicaid that goes with it that is really tough, because remember, these Medicaid waiver programs, CLAS, HCS, those kinds of programs, we want to make sure that our kids are eligible for these programs. So again, make sure you look into long-term planning, think about how it is that you can make sure your children maintain eligibility. If you want help just kind of talking through these issues, feel free to call me. If you call my office and schedule an appointment, if you tell them you're calling from the ARC of Texas referral program, from our presentation or something, I won't charge a consultation fee. Just tell my secretary that there's no consultation fee. And we can just kind of talk through your specific situation. And I'd love to help you. But for now, if there are any other questions, I'll take those.
I don't see any that came through right now. If anyone has questions, put them in the Q&A box. We